now let's deal with the issue, the hand of Honorable Lorema. Is there any other hand? Going 1, 2, 3. There's no other hand. Honorable Lorema.
Thanks, Mr. Chair. I had thought that we were a committee of parliament and that we had oversight over the department, so I don't understand this contention that we don't get to see certain internal reports. I find that completely incorrect. We're obviously getting from the Minister that we're not going to see this report. So the question is, why not? And Minister, I'm afraid I don't accept your answer. I think we need more than that. It looks like it's being kept secret from us, and I'd like to know why.
Okay.
Honorable Chairperson.
Yes, Honorable.
I accept that Honorable Lorema doesn't accept my answer. But maybe we need a day to discuss this thing called separation of powers. What does it mean in practical terms? Because if that is the case, we can just integrate government. No powers, judiciary, executive, parliament. If we say every internal operation of one should just be given to the other. But I accept that he doesn't accept my response.
Okay, can I understand? I understood to be the answer to, so that we the answer to be saying the issue of the investigation. The investigation was done by the department in order to improve performance as far as the licensing backlog or the licensing application is concerned, and therefore the report will be part of it will be contained in the presentation on the cadastral system. It was not necessarily a report that was done for purposes of prosecution per se. I hope I understood to be what it says, but I will leave it to honorable members probably when we are done with regards to then what is the attitude of the committee. Can I give the minister to lead? I'll allow minister that we deal with both, and then we will take questions on the first presentation, and then we'll go for questions on the second presentation. Can I give it to you, Honorable Minister, and your team?
No, thank you very much, Honorable Chairperson. We will give a report on the environmental rehabilitation of mining, prospecting and exploration activity. I will ask Acting DG Caesar to lead the team to make the presentation to the committee. Thank you very much.
Thank you very much, Honorable Minister, Honorable Chairperson, honorable members, the colleagues who have joined the meeting. Good morning, and thank you for the opportunity to address you in terms of the matters. The first presentation will be done by Advocate Malibe. Then thereafter, in line with the direction from the chairperson, will receive the presentation from Memolot, Memshongo, will also be supported later on by Ntate Maqubela. So I'll request Advocate Moloto, she can start with the first presentation. Thank you.
Good morning to the Honorable Chair, honorable members of the committee, Minister, Acting DG, colleagues and members in the call. I'll be presenting on the financial provision. If I can ask the presentation to be slided.
Don't sometimes been given co-hosting rights.
Apologies for that. There's a slight delay in sharing of the presentation. I am trying to share it, members. Just a second, please. Thank you.
Okay, thank you.
I thought I was seeing the presentation and then I see it disappeared again.
Yes, our apologies again, Chairperson. But what can I suggest that if through the indulgence of the committee, Memoloto can just introduce the presentation, and then we, in the interest of time, and then I'll, with Mendebele, trying to put it through. Thank you, Chairperson.
May I proceed?
Yes, I think for us as honorable members, we do have the presentation. The only thing we may not see you, I don't think that is a danger. Whilst we are still trying to put the presentation in, we are trying to flag the presentation. Just tell us which one you are starting with. You are starting with the rehabilitation.
Yes.
Okay, continue.
Thank you, Chair. On the presentation outline, its background, legislative evolution, the effect of business rescue, determining financial provision, and conclusion. On the first slide, we have the background, where we say in pre-2014, there were parallel application processes in terms of the MPRDA, NEMA, and NEMA Waste Act. However, after 2014, the two ministers of DMRE and the DFFF agreed on one we call the one environmental system. And in terms of that one environmental system, all the environmental provisions were removed from the MPRDA, and the financial provision were amended and incorporated into NEMA and its regulations. I'm on the background slide. And okay, thanks. And the financial provision is now provided for in terms of section 24P of NEMA, which will then include, as part of the one environmental system, the arrangement was that the Minister of Environment will set legislation, norms and standards, and the Minister of Mineral Resources and Energy will be responsible for licensing, compliance and enforcement. Next slide. What we have here is the legislative environment that is governing the financial provision and environmental management at large, but now we're focusing on the financial provision. We have the National Environmental Management Act of 1998 as amended, together with its own environmental impact assessment regulations of 2014, and also the financial provision guideline, which was implemented in 2015. And we also have the Waste Act in terms of the NEMA with its regulations. And we've got the National Appeals Regulation and also the income tax, specifically section 37. Next slide. In this slide, Chair, we're giving the evolution of the financial provision, where it comes from, when it started. From the beginning of time, we are aware that mining in South Africa happened more than 100 years ago. Back then, we used to have a common law agreement. It will just be an agreement between the applicant or the holder of a right and the landowner. There was no law which was forcing them to implement any environmental legislation, including the financial provision. With the evolution of time, we had the Mining Rights Act of 1967. Still in 1967 era, there was no rehabilitation or no provision legislation. Then we transited to the Minerals Act of 1991, where we introduced section 38 and 39, which spoke about the rehabilitation and restoration of the environment, including forcing the holders to submit what we call environmental management program. And those two sections only came into effect in 1996. So you can see that from the evolution of time, we never used to have strict regulations or laws relating to financial provision. And that's basically the reason why today we're sitting with what we call derelict and ownerless mines, which the fiscus is funding for rehabilitation because of with the mining happening, like I said, over 100 years, there never used to be any law or even stricter law on the actual rehabilitation and financial provision. Then in 2002, we moved to the MPRDA, which was also promulgated in 2004. And we had section 41, 43, and 44. Those sections then spoke about integrated environmental management and also the rehabilitation and financial provision. So that's where we are starting to be strict on demanding financial provision to cover for the rehabilitation and also on the integrated environmental management. Then we moved to NEMA. As I've indicated before that in 2007, 2008, we had what we call the one environmental system. And in that one environmental system, as I indicated, the two ministers agreed that we'll remove all the environmental sections, the one that I've mentioned before, the section 41, 43, and 44, that were used to be in the MPRDA. They were then migrated into NEMA. And as part of that, we then have section 24P of NEMA, which specifically talks about financial provision. That's what we call the financial provision regulation. And it's those regulations that came into implementation or promulgated in 2015. Again, with the gaps that we have seen throughout the years as and when we implementing the environmental management and financial provision, we in 2022, together with DFF, we're starting to strengthen all the laws on environmental management, including financial provision on rehabilitation. As of 11 July 2022, the regulations were taken out for consultation, specifically on the financial provision. It proposed certain amendments just to strengthen and close the gaps that we've seen on the calculation of the method of the financial provision, because at the moment we don't have a method or a scientific method that we use to calculate the financial provision, and that's something that we're working on together with environmental affairs, and also the percentage on the retention of the financial provision after all rehabilitation is done. This is something that we also have realized that is a gap, and we're working on it to close that gap, because at the moment we don't have that percentage to say. If we say the minister is going to retain a portion of the financial provision, it is not clear at this stage what percentage can the minister retain. So this is one of the issues that we are working on as part of the amendments. The next slide. Now, if you go to the definition of financial provision, it means the insurance, bank guarantee, trust fund, or cash that applicants for environmental authorization must provide in terms of NEMA, guaranteeing the availability of sufficient fund to undertake the rehabilitation of the adverse environmental impact of all the listed activities, because in terms of NEMA, there's a whole listed activities that are promulgated in there. Again, it talks about rehabilitation of the impacts of the prospecting, exploration, mining, production activities, including the pumping or treatment of polluted or extraneous water, decommissioning and closure of the operations, remediation of latent and residual environmental impacts, which became known in the future, the removal of building structures and other objects after mining and after closure, and remediation of any other negative environmental impacts. And that's the reason why we are having financial provision. That's why financial provision exists. Next slide. Now, if we go into section 24P of the financial provision for the remediation of environmental damage, I'm going to take it as read, Chair, if you allow me. This is the legislation as stand on the financial provision about what needs to happen, that the applicant for environmental authorization related to prospecting, exploration, mining must comply before an environmental authorization is granted by the minister. And if the holder or any holder fail to rehabilitate or to manage any impact of the environment or is unable to undertake such rehabilitation, the minister responsible for mineral resources may, upon reaching notice to such holder, use part of the financial provision to rehabilitate. And every holder must annually assess his or her environmental liability and submit the audit to the minister responsible for mineral resources on the adequacy of the financial provision from an independent auditor. Next slide. Section 24P continues to say the minister responsible for mineral resources is not satisfied with the assessment of the financial provision. The minister may appoint an independent assessor. Let's say there's disagreement between the department and the holder to say how much should be in the financial provision, and the minister is not happy with what has been presented. The minister is allowed to get an independent assessor to assist on how we determine the financial provision. And the cost of that assessment will be borne by the holder in question. And there's also the requirement to maintain and retain the financial provision after issuing of closure. And as I've indicated before, this specific requirement here on the regulation is also under amendment because the challenge was that we did not have a percentage on how are we scientifically going to come up with the percentage to say after the holder has rehabilitated, we can keep this percentage as the DMRE for any latent defects or any residual environmental impact. Next slide. This country was a desert and returned into a forest where everything. And we also have the, as part of section 24P as well.
Sorry,
sorry.
I think okay, now we can continue now.
Okay, thanks, Chair. I was saying in terms, as we continue in terms of section 24P, the financial provision for rehabilitation of mine does not form part of the company's assets and thus cannot form part of its insolvent estate. Let's say the company gets liquidated or is under business rescue. The financial provision in the custody of the department will not be used as part of the process of liquidation or business rescue, and that's part of the Insolvency Act. Next slide. As we unpack the effect of business rescue on mining companies, that the business rescue process is necessary legislative mechanism to facilitate the rehabilitation of a company that is financially in distress. And that there's going to be temporary suspension of the company and its affairs, business and property. And that also places a temporary moratorium on the rights of claimants against the company in respect to the property in its possession. And it also allows for the development and implementation of a plan to rescue the company of its affairs, debts, and other liabilities. And it also maximizes the likelihood of the company continuing in existence on the solvent basis or in a better return for the company's creditors or shareholders, and also to minimize the impact it will have on creditors and shareholders if the company had been instead liquidated. And all these processes of the business rescue are in terms of the Companies Act. The next slide, please. Placing the company on business rescue it can happen either the board of that company can adopt a resolution and do a voluntary process to put the company under business rescue, or it could be as a result of the court order, where anybody who's got an interest or affected on that company can apply to court to put it under business rescue. And if liquidation proceedings have been commenced against the company at the time of application is made, the application will suspend those liquidation proceedings until conclusion of a business rescue proceedings. Next slide. Now, the moratorium on a company that is on business rescue. During the business rescue proceedings, there'll be no legal proceedings, that is enforcement action related to any property belonging to the company, except with the written consent of the practitioner or the courts as an offset against any claim made by any company in any legal proceedings, or proceeding concerning any property or right over which the company exercised the powers of a trustee, proceeding by a regulatory authority in the execution of its duties after written notification of the business rescue practitioner. Here specifically, if we relate it to mining, let's say for instance, a mining company is under business rescue. If as a department we want to continue with our enforcement action, be on the financial provision or any other non-compliance, we need to get the written consent of the business rescue practitioner, or if not, apply to court to enforce our law in terms of the company that is in business rescue. Next slide. And then during the business rescue proceeding, a guarantee or surety by a company in favor of any other person may not be enforced by any other person against the company, except by leave of the court. And if any right commences or otherwise assert a claim against the company, that will be subject to a time limit or a prescription in terms of law. For the measurement of that time must be suspended during the company's proceedings, business rescue proceedings. Next slide. Now we go to the methods that we have that the holders of rights or permits can use to fund the financial provision. The first one, we've got the financial bank guarantee from a financial institution registered in terms of the Financial Services Board. And we've got the cash deposit into the account that is administered by the minister responsible for mineral resources and energy, and also a contribution to a trust fund that complies with Section 37, the Income Tax Act. Next slide. Now, if we unpack the first method, which is the financial guarantee, the financial guarantee will be provided by a registered institution in terms of the Banks Act, or from a reputable financial institution that will be registered with the Financial Services Board. And that financial provision or that guarantee must comply with the Prudential Authority requirements for issuing non-life insurance or financial product. And the minister is also able to claim against the guarantee where the company has failed to meet its obligation and apply the funds for rehabilitation and remediation of environmental damage. What's happening at the moment is if anybody or any holder wants to withdraw the financial provision, this guarantee, before a closure certificate is issued or before they finish mining or for any other reason, they need to inform the minister of their intention, because as the department will have interest to know if the state is covered at all times. The next slide. The second method of financial provision I said earlier is the cash deposit. This fund is administered by the DMRE Rehabilitation Trust, which was established in 2003 to provide for holders with an option. If they don't want to use the financial guarantee, they can use this method of cash deposit. And prior to the establishment of this trust, cash deposits were kept in the departmental suspense account. But as a result of the amendment or the promulgation of the PMFA in 1999, the state was prohibited from holding any other funds, and that then necessitated the department to establish a trust. And the trust is also always under audit. It was audited recently by the AG in 2020, and it obtained a clean audit. And the trustee of this trust are officials in the employ of the department, the DMRE, and the secretarial and admin function of this trust are performed under the scrutiny of our Chief Financial Officer. Next slide. Still on the cash deposit, the trustees will receive, invest, and administer such funds from the holders for the sole beneficiary and for the execution of rehabilitation of operating mines. It's only related to operating mines. It's not related to any derelict or ownerless mine or any other. It's only for those mines that are operating as and when they are annually providing for their financial provision as the law requires. They'll be putting in the cash into the trust for their own operation. As and when they continue with concurrent rehabilitation, they'll come later on and claim the money back from the department. So the money should be always available for them as operating mines. Upon discharging its statutory rehabilitation obligation to the satisfaction of the DMRE, funds deposited by the beneficiary must be placed at disposal of that beneficiary. Should the beneficiary fail to carry out its statutory rehabilitation obligation, funds will be placed at disposal of the DMRE for rehabilitation, and the DMRE can take that money on behalf of the holder who's not able to rehabilitate and go and rehabilitate. Should there be any balance outstanding to the credit of the beneficiary after all measures were taken and has been executed as per the satisfaction of the DMRE, that balance shall be kept in the trust for the beneficiary to be utilized for future rehabilitation only. And this account is administered by the minister and is therefore a trust which accepts contribution from beneficiary for the sole purpose of their rehabilitation obligations. Next slide. And then the last and the third method that we mentioned is the trust fund that is managed outside by the holders, and the holders will be contributing in terms of Section 37A of the income tax, and deductibility of contribution made to mining rehabilitation of company or the trust. And also it talks about the types of rehabilitation expenditure provided for in the Income Tax Act, and qualifying asset of mining rehabilitation company or trust, which is the asset held solely for purpose of rehabilitation. Distribution of property by a mining rehabilitation company or trust at closure or decommissioning, or positive balance remaining after obligations have been met. And also the tax treatment of this fund will be done by SARS, where SARS will indicate if the holder qualify for any deductions. Ours as the department is to annually or as and when it's required to make sure that this trust fund is still active, is still valid, so that the rehabilitation provision is secured at all times. Next slide. How do we then determine the financial provision? The Act places the obligation on the applicant to ensure that a determination is made of the financial provision, and the plans are submitted for consideration by the minister as indicated before the environmental authorization is issued, and financial provision at any given time will equal to the sum of the actual cost of implementing the plans and report for a period of 10 years post-closure. And that is also determined or assessed by a specialist, and financial provision liability may not be deferred against the assets at the mine during closure or mine infrastructure. Let's say the mine has a shortfall on the financial provision and they indicate that they don't have money. They cannot use the infrastructure of the mine to defray the the cost of financial provision. And where a bank or an insurer is used for payment or adjusting the financial provision, verification of registration of that financial institution must accompany the proof of payment. Next slide. I've indicated before, Chair, the three methods that we use for financial provision, that is the cash, the bank guarantees that is held by the financial institution, reputable financial institution, and we've got the trust fund in terms of the Income Tax Act. Now, in terms of the cash, as in November 2022, we in possession of 3.1 billion of the cash that is rotating for the operating mines to claim as and when they rehabilitate to our satisfaction. And we've got the bank guarantees that are sitting with those institutions to the amount of 66.9 billion. And we also have the trust funds that are at the amount of 24.5 billion. Next slide. Now, the powers of the minister in terms of the act, the minister may only grant the environmental authorization after arrangement have been made for financial provision and proof is provided. That is important, Chair, so that we make sure that we don't repeat the derelict and owner-led mines that we're sitting with where there was no financial provision. After all the processes have been done, the applicant applies, comply with the requirements, and everything is done, before the EA is granted by the minister, the financial provision must be in place to make sure that the state is covered at all times. And if the minister is not satisfied with the calculation or the assessment, the minister may request the holder to revise at own cost those calculations or appoint an independent assessor. And I've indicated before that the minister may retain a portion of the financial provision based on the environmental risk report on issuing of the closure and must retain the remaining financial provision. I indicated here that this was one of the challenges that we would face currently. And that's why, as part of the amendments, we are talking with our colleagues at Environment to come up with the scientific calculation or a percentage of how much can the minister hold or retain for any latent defect or any residual that may come after closure. And again, if the minister has got the powers, if the holder of the right or permit fails to rehabilitate, the minister may rehabilitate on their behalf and claim the cost from the holder. The next slide. Here we've got offenses under financial provision, that is for non-compliance. And the regulation places an offense on if any person contravening the financial provision regulation, either if not to have it sufficiently covered, if there's a shortfall, for instance, will do the processes in terms of admin justice and ask them to make sure that the rehabilitation is fully funded, or if they withdraw the financial provision without our permission, like I indicated before, especially in terms of those methods that are not within our authority, like the trust fund, if they decide not to continue paying into the premiums into the trust fund and not making sure that the trust fund is active, or not making sure that bank guarantee at the bank is serviced, that is a contravention, or not having it covered after being directed to do so. If a directive is issued and they fail to adhere to the directive, that is an offense. How do we make sure that we monitor that? We will do compliance inspection and audits periodically to verify the adequacy of the financial provision. And I mentioned before that the financial provision is revised annually. And where there's a shortfall, the holder is directed to correct the shortfall. And if the holder failed to rectify any of the above, and after they've been directed to do so, Regulation 18.1 may result in the holder being convicted to a fine not exceeding 10 million or imprisonment for a period not exceeding 10 years, or both. Next slide. Now, how do we deal with mine closure after everything has been done and the holder has rehabilitated to our satisfaction. Application for closure is in terms of section 43 of the MPRDA. And then that application for closure must be accompanied by a closure plan, a financial performance assessment report, environmental risk report in terms of the MPRDA. And then that will follow the reinvestment of the cash deposit that is in our possession upon issuing of a closure certificate. Now, submission of reinvestment must have the following. Before that, Chair, let me mention that when the applicant applies for closure, when we do a compliance inspection, we do that jointly with Department of Water Affairs, because we know that in terms of maybe, let's say, extraneous water that may come up as part of the residual or the latent defect, example of the AMD, acid mine drainage, then not environmental affairs. Water affairs will be involved as part of the closure. Now, once everything is done and then the reinvestment of the financial provision, they must have full details of the holder, the copy of the permit of the right and the closure certificate, amount provided, an amount to be refunded, proof of banking details, and affidavit in case it's claimed by a third party. And in terms of this process, no refund will be made if the holder owes any prospecting fees. This will be in the case of a prospecting holder. The next slide, which is our last slide, Chair. We say in conclusion that we appreciate that over a century of mining where environmental regulation was not part of our law, as I indicated, this has resulted into the state inheriting the liability of those mines where the holders cannot be traced. And this is part of what we're dealing with now, that we call the derelict and ownerless mines that are apportioned by the fiscus for us to rehabilitate. This is a result of the legacy that we enjoyed because we did not have any environmental legislation in the past. And this position has been drastically changed in the legislative amendments since the MPRDA, the Minerals Act and NEMA, as indicated earlier. And of course, the financial provision for rehabilitation is currently highly regulated to ensure that the state does not inherit any responsibility for rehabilitation where mines prematurely decommission. And this is a commitment that the department is discharging rigorously. Thank you, Chairperson. That is the conclusion of our presentation. Back to the DG.
Thank you, Advocate. Through yourself, Honorable Chairperson, then we'll move on to the next presentation, which will give the status on the cadastral system. But what we'll do as well, Chairperson and honorable members, is that we'll also talk to the progress made on the licensing backlog, but not only that, but just to give an overview on what interventions or measures we put in place to strengthen the controls in the region. So the presentation will be done through Mem Mhlongo and supported by Ntate Maqubela. Mem Mhlongo, over to you.
Thank you, Chairperson, and good morning, honorable members, honorable minister, colleagues and officials from the department. I will be taking members through the report on the cadastral system. How we have packaged the report is that we will give a brief history of the system. We will also indicate the capabilities of the system. We went through a diagnosis process in the department, and I will share the findings. The department has also previously implemented measures to address challenges. I will share what the department has done. And we are currently in the process of replacing the system. I will share the progress on that and the next steps. We will also share the status on the licensing backlog. Next slide, please. In terms of the history of the system, it was deployed in the department on the 18th of April 2011. The system was deployed as a new capability to receive applications online so that thereby reducing the need for applicants to travel to regional offices to lodge mining applications. The current system is divided into 4 components. The first component is the portal, which is the public-facing portal. It is used by applicants to submit their applications. I must indicate, Chairperson, that this was developed specifically for the department by the service provider, and the contract at that point in time excluded the IP ownership. The second component of the system is the cadastral system, which is used by both the applicants and internal staff for the identification of land parcels where mining and prospecting applications or rights are geographically located. Under the cadastral system, the 2 technologies that we have is the Buffalo software and the Esri platform. The third component on the system is the Harrington Quality Management System. It is a backend system, which is an internal facing workflow that we use to adjudicate applications. The fourth component is the payment gateway, and that is used to handle the collection of application fees. In terms of the capabilities of the system, when it was deployed, it was to be utilized for online lodgement of applications. It was to be utilized for application document handling and uploading, online application payment collection, automation of adjudication of applications through the workflow component, the cadastral system, and it also has reporting capability. Next slide, please. Chairperson, the department went through a process to assess the system and do some diagnostics to identify challenges that we may be well aware of. And we have categorized the findings or the challenges as per the evaluation process. The first one, I will talk to technical system challenges. The current system is under-specified. In fact, our infrastructure is not capable to carry the software and is also not capable to carry future upgrades on the software. The other challenge that we experienced was when we were moving data from Buffalo to Esri. The other one is moving data from NPS to the current SAMRAT system. In terms of the quality management system limitations, the component is rigid and limited in terms of customization to suit departments' processes. The current system may collapse should any more enhancements be introduced. The system also only works on old technologies, and those technologies are not supported currently. The technology on workflow is also no longer supported by Microsoft. The second set of challenges that we identified was on the system support. The company which was developing and managing the system was liquidated in April 2016. SAMRAT has not been upgraded further since the liquidation of the company. The rights of ownership, that is the intellectual property, was owned by the service provider, which posed challenges for us when we wanted to work on the system. If the service provider was not cooperating in terms of providing us the rights, it posed a challenge to the department. Further changes to the off-shelf package was not possible without risking the total collapse of the system. Next slide. In terms of functionality, the following challenges were identified. The first one is that SAMRAT is not a fully interactive system. The technology is not robust and is also not scalable. The department had to conform to the system capabilities as configured by the service provider instead of the system addressing the needs of the department and the users. In terms of the contract, as part of the declaration during the launch in 2011, key considerations were taken into account, which included transparency during processing of applications, accountability for licensing officials, and transparency in decision-making. Following these declarations agreed upon, it posed challenges to the department in that every document that was uploaded had to be uploaded individually, and therefore for any searches that are performed on the system had to be performed individually. The system is unable to pull a snapshot of a particular area, be it for compliance or for reporting purposes. For an example, if one needs to make an assessment or draw information for a particular province or district or municipality, the system is unable to provide detailed information. The general land availability inquiry was switched off due to the strain it caused on the infrastructure. In terms of the portal, which is client-facing, forms need to be developed to allow online completion of templates instead of uploading PDF format that also cannot be interrogated. To allow the department to have information that can be used for decision-making, the system also does not provide enough intelligence or data. The system also poses a challenge in that it is not compatible with other internet browsers, including mobile devices. In terms of the workflow, which is the back office processing, the system does not provide a seamless way to facilitate workflow required to allow users to adjudicate on applications. There is no direct interface with other systems or verification processes. For an example, if we have to draw information from other government departments like Home Affairs or CIPS, it has proved to be a challenge as there is no direct interface. And that does impact on turnaround times. In terms of the GIS, which is both client-facing and back office processing, the updated spatial data from the Surveyor General is not updated instantly, and it is due to the challenges of direct interface that I have mentioned. Next slide. Having identified the challenges, Chairperson, I have indicated that the system was deployed in 2011. There are measures that the department had put in place previously to try and address those challenges. And I will go through some of the interventions that we put in place. Over the years, the hosting problem was incrementally corrected. However, that process was not completed. We have changed the open source software, which is called Buffalo. We changed that to Esri, and it is performing. An integration program was initiated with the aim to replace SAMRAT, and we also incorporated the entire MPRDA and other related acts which governs the space. The integration program was divided into 3 projects. The first project was on process maps and enterprise architecture and governance. That project was completed. The replacement of the SAMRAT system also incorporated the related acts, and it was to integrate the entire DMR value chain and efficiencies. This was intended to remove silos in the department, to improve turnaround times, to improve data quality and reliability, as well as to increase accountability and reachability of the department through electronic channels. Some of the measures that we put in place, Chairperson, proved not to be effective in addressing the challenges, and therefore the department took a decision to partner with SITA. I need to mention, Chairperson, that SITA is actually mandated to procure certain IT products for government departments. Therefore, for this process, the department partnered with SITA and handed over the procurement process to them. They went through the procurement process. The department did compile the terms of reference or specifications. We handed that over to SITA. They advertised the tender. The evaluation process took place. At the point of appointing a service provider, Chairperson, through their own internal processes, they had to conduct audits. An audit was performed by their internal auditors and external auditors. The focus and scope of the audit was on the procurement processes. Unfortunately, Chairperson, as they conducted the audit, there were findings that were made on the entire procurement process, and I will touch on that in the next slide. The other intervention that we put in place to address the challenges was to replace the infrastructure. As I indicated, it is unable to carry the software. That procurement process is in progress, Chairperson. As I have indicated, there were findings that were made by SITA internal auditors and their external auditors that identified some process flaws in the procurement process. The management of the department, including the DG, met with the acting CEO at SITA and the project managers who were working on the procurement process. They took us through the findings, Chairperson, and on their advice, and based on our own assessment as a management team in the department, we both came to a conclusion that the process should be cancelled to avoid audit findings in future. The measures that we have put in place in the department, based on some of the findings that were highlighted by the audit reports, we have embarked on a benchmarking exercise to gather some insights and learnings from other countries that have implemented a similar system. We have benchmarked at Namibia, And there's some insights that we gathered, and those we will take into consideration when we finalize our specifications. We were meant to also conduct a benchmark with the Republic of Botswana. They have just launched their system on the 1st of November 2022. They have a request, Chairperson, that we postpone the benchmark so that we can afford them the opportunity to launch the system, find any glitches, and also give them the opportunity to stabilize the system. So we are waiting on them. We may have to benchmark with them the end of November. There are other parallel processes that are running internally, Chairperson, to procure this new system. We are strengthening the capacity to implement this project. We want a dedicated project office with individuals with the competencies and capacity to implement huge ICT projects. And in strengthening that office, Chairperson, we are currently seeking for approval for to appoint a contract manager, ICT project manager, who will oversee this project. We are doing this, Chairperson, so that we have a dedicated resource that will not be involved in any operational work, but solely focus on managing and ensuring that we successfully and timelessly implement this project. Part of the deliverables for this contract ICT project manager would be to develop a project plan and also to develop a risk plan so that as we implement the project, we also mitigate risks that comes with implementing IT-related projects. We are also currently cleansing our data, Chairperson, so that when we migrate to the new system, we have data that is accurate and that is up to date. At this point in time, we have concluded 60% of our data cleansing project. We are also ensuring that by the time we deploy the new system, we have dealt with the backlogs. And to date, Chairperson, I can report that the backlog are reduced by 43.5%. And I will cover the breakdown on how the provinces are faring in my next slide. We are also in the process of developing the terms of reference for procuring this new system. We have given ourselves a target date to complete the specifications by the end of November. And that process will be overseen by our bid specification committee. We have also committed, Chairperson, to advertise the bid by the 15th of December 2022 before people go on holidays. And in terms of this process, Chairperson, we will be engaging CETA just to concretize as to whether we are allowed as a department to advertise the bid ourselves, or whether they will advertise the bid for us and oversee the project. However, Chairperson, I must indicate that whether the bid is advertised internally within the department or with CETA, we have concretized that we will advertise that bid on the 15th of December. Next slide. In terms of the status on the licensing backlog, we have categorized the data in terms of mining rights and prospecting rights. And Chairperson, for the sake of time, I will just go through one province and a similar narration can be taken into consideration when you read the data to horizontally. In terms of mining rights, as per section 22 for Mpumalanga province, we are having 4, in terms of the backlog, we are remaining with 40. For the renewal of mining rights, we are having 8 outstanding. For section 11, 13 outstanding. Section 102, 77 outstanding. SLP section 102, regulation 44, we have 28 outstanding. In terms of prospecting rights, section 16, in terms of section 18, we have 43 outstanding. Section 11, we have 12 outstanding, and section 102, we have 9 outstanding. As at March 2021, the department had a backlog chairperson of 4,647 applications on 3 licensing categories, which is mining permits, mining rights, and permit rights. Currently, the backlog has been reduced to 2,625, which equates to a percentage of 43.5% reduction from the previous backlog. Chairperson, I will pause here and request DDG Makubela to just talk more on the project to address the licensing backlog. Thank you.
No, thank you very much. Good morning, Honorable Chair and Honorable members, Honorable Minister, DG, and colleagues who are on the call. I just want to address 2 issues. One is that we have done an assessment of what was the issue or the challenge in actually making sure that the work moves. And we've come up with 2 issues. One is a structural issue. The second one is a culture issue in the organization. So the structural issue is that we found that the same people who have to do licensing, who have to process licenses, are the same people who have to go and conduct compliance inspections. So that is a structural issue, and I think we believe that that issue needs to be attended to, and a process to attend to that issue has been initiated because the minister has asked us to have a structure that basically is responds to the mandate, the dynamic mandate that we have. So we think that separating the licensing and compliance is one such initiative that would have to be undertaken. The second one is a cultural issue. And the cultural issue basically talks to, issues of making sure that all of us do the right thing all the time, even when no supervisor is watching. And I believe that we are getting on top of that issue, the culture change. What we've done is that we have made, we have institutionalized certain routines in the organization. We have what is called the licensing committee, made up of the 4 chief directors as well as the DDG. And we meet regularly on a 2-week frequency. So that is a routine that is established. So in that licensing committee meetings, that is where all the licenses then that have been recommended are then looked at. So if you are responsible, for example, for Northern Cape, the one that is responsible for Mpumalanga will then have sight of the license applications and then would be able to then ask questions on whether certain things have been done. And we do from time to time refer back licenses where we believe that there are certain areas of compliance that have not been dealt with. So I think that is what I wanted. I think the culture issue, for example, we bring the regional managers to come and meet with us to explain to us why the backlog is not moving. So we do remain with 2 provinces now that we think we still need to put a lot of effort in, and this is the Northern Cape as well as Mpumalanga. I think part of the challenge in Mpumalanga is that there are many license applications for mining permits, and they do take quite a lot of time to process, but then that actually the chances of those particular licenses succeeding is limited. I mean, in the 2,000 odd licenses that we have processed in the last year and a half, basically 70% resulted in refusals. And yet a lot of effort went into that. Some of the challenges that we see is, financial capacity of some of the applicants, one. Secondly, people apply where there's already an existing, right holder. The one thing that we want to indicate that here is that the 14-day, turnaround for responding, I think still remains a challenge for us. And it is an area that we still need to focus on. We are not really on top of that in particularly in the provinces where there are a lot of applications. And so I think what we also have introduced is that when there is a complaint by a member of the public or one of the other parties that is aggrieved, we immediately request our internal audit to then get involved so that we get to the bottom of whether this is just a frivolous complaint or whether there is substance to it. So that has been entrenched in the organization. I guess also I must indicate that to the displeasure of our audit committee, because they feel that we are overburdening internal audit, but we have no choice sometimes but to involve an independent structure of the organization to make sure that people do the right thing all the time. Thank you very much, DG. Thank you, Chair.
Thank you. Thank you very much, Kubela, Advocate Maloto. Thank you, Honorable Chairperson and honorable members. That will be the end of the two presentations. Thank you.
There you are, Chairperson. We're handing over to you.
Okay, thank you, Honorable Minister, Acting DG Msiza. Can we first start with the presentation on rehabilitation and financial provision? Is there any take? Going one. Going two. Okay. I see the hand of Honorable Matoke. I see the hand of Honorable Lorena. I see the hand of Honorable Malinga. Okay, continue, Honorable Matoke. It's only the three of you. I'll come after Honorable Malinga.
Thank you, Chairperson. Greetings to the Minister, representatives of the DMRE, the committee members, and everyone that is in the meeting. I just have a few questions in relation to the presentation. The first one being whether, as things stand right now, the department has an updated database of licensed mines in relation to their contributions to the funds that are expected of them, that they are supposed to contribute towards, and whether currently, as we're sitting here, we do have license holders that are defaulting. What is their percentage and what is the intervention from the department in that regard? The second one, I think that in terms of the fines or the implications or other consequences of not adhering to the laws, it is said, I just forgot the slide number, that one is susceptible to a fine that is not exceeding 10 million. So I'm interested in what informs the cap being 10 million rand, and what happens in the event that the damage that has been done actually far exceeds the 10 million rand that has been made as a maximum amount that is due. And I think when it comes to closure and rehabilitation of mines, the biggest elephant in the room is the mines that were there before the legislation, which at this point in time, the department has to a certain extent alluded to or given an impression that they do not necessarily have a plan in terms of addressing that elephant, mainly because of budget constraints, and that even if they were with the budget allocation that they have, they could take up to 20, if not even 30 years to actually see that these mines are closed. And I would have actually expected that the report also speaks to what is the plan to ensure the rehabilitation and the closure of the mines that are currently there, that were there before the legislation, that the department has basically been grappling with. Because we are actually, and we have said that we are dealing, or we are facing a challenge right now of illegal mining. And where illegal mining is happening mostly, it is in mines that have either been abandoned or in mines that are actually due for closure and rehabilitation, which at this point in time, the department does not have a plan in terms of addressing them. And I think my final question, Chair, when we were in Mpumalanga, we saw a huge and disturbing illegal mining activity where community members said, look, we started reporting this to the department while these people were still starting. It had not even been perhaps as mammoth as it was now. And when we got there, it was a full-blown, full-on mining activity. And if you are to look at the amount of money that must be used to actually rehabilitate that area, it would be a lot of money. So I am interested in what then becomes the role of the department in terms of ensuring the rehabilitation and closure of the effects of illegal mining, which perhaps had been reported to them on time, that they had not acted on time, and to a point that right now communities are sitting with this problem. Because I think that the response that we got of polluter pays. They're expecting the people who are doing illegal mining, which are criminals, to now all of a sudden turn and be good-hearted people who put environmental issues at heart, which is not going to happen. So what becomes the role of the department in that regard? I think even when we went to Gauteng, literally illegal mining activities were happening near communities. And you will find out that one of these days we'll be told that a child fell into a hole because it's literally a meter or 2 meters away from communities. So what becomes the role of the department in that regard? What provision are they making? But I'm more interested as well in where these activities were reported to the department before they got out of hand. Nothing was done, and now we're sitting with the problem. Thank you, Chair.
Chair, first of all, I think it's a very informative presentation, this one. I'd like to focus on slide 13 with regard to the business rescue practitioners and about them having the ability to hinder the enforcement of regulations. So really, I think the question is, how often has the DMRE been blocked by business rescue practitioners from getting regulatory orders enforced? And has the DMRE even had to go to court to get the business rescue practitioners to carry this out? So really, I guess I want a picture of whether this process hinders enforcement action and whether the department believes there would be ways to streamline this process to make it easier. Thank you.
Thank you, Chairperson. Greetings to the Minister, DMRE team, colleagues, and everybody on call. Chairperson, let me also welcome the presentation. I hope I am audible. I am challenged. Chair, let me welcome the presentation as presented by both Ms. Muloto and Mem Hlongo. Chair, you see, to be the last speaker is you are not so lucky because some of your thoughts and your questions are taken by prior speakers. Chair, I want to zoom in on the last point that was raised by Honorable Lorima. Actually, my question is different from his. That how is it possible that they can get a consent, the department can get a consent from a BRP to get that financial provision? Because, Chairperson, with companies or mining houses that have been under BRP, I think the last time we had such an issue, it was said that the department could not do anything because the mining houses were under BRP, which is what we've been drumming on as this portfolio committee, that BRP are not doing justice to the department on their oversight when companies, they go under BRP. So I heard on the slide that Mem Lotto said they can ask for a consent or go to a court of law. How can a court of law force the BRP to pay that financial provision, Chair? Also, on their slide, Chair, on financial provision, I did not see where illegal mining is happening due to mines which are under care and maintenance. What happens in that case? Where a mine is under care and maintenance, do they still continue to pay for this financial provision? Because I did not get a sense on that one. Maybe I missed it, Chair, but if I can just be clarified on that one, Chair. Thank you very much.
Okay. Honorable Minister and your team.
Thank you, Honorable Chairperson. I will allow the team to come in. I will just fill the gaps. And Ramses.
Thank you, Honorable Minister. I will also allow Advocate Moloto just to start off, and we'll add where necessary. Advocate.
Thank you, Chair. Thank you to the Honorable Minister and the DG. The questions from Member Madokwe on the database of operating mines and license holders, those that are defaulting. As and when we issue a right, be a mining right, mining permit or prospecting right, and as I've indicated on the presentation that before that right is issued, we make sure that the financial provision is paid before the environmental authorization is granted. So which means that we'll have the name of the mine or the holder against the financial provision that they must pay. And then from time to time, as we have said earlier, that we revise they're expected to revise the financial provision annually. We will have a database of those rights that those holders that we've issued the rights against the financial provision that are expected to pay. And also if there's a shortfall, we'll have the X amount of the shortfall. And then we'll start the process of non-compliance for them to close the shortfall. So at any given time or at all times, we'll have a database of all those operating mines together with their financial provision and their shortfalls. And there was also a question on what informs the cap of the 10 million. As per the regulation, Chair, and I've mentioned that the Department of Environmental Affairs is responsible for doing the regulations and the DMRE implement. And this was a negotiated process that was consulted widely with all the stakeholders to come up with a sort of an amount while we're looking at what would be at the mine. We're looking at, if you calculate the quantum for financial provision, we'll be looking at what is on the ground, how much or to what extent of the ground being damaged. We look at the infrastructure that is on the ground at the mine. And then based on the combination of those, then the amount was decided to say, let's cap it at 10 million or imprisonment or both. So that should anything happen, they're not able to rehabilitate, the state can take that money and go and rehabilitate. And what is happening here is that operating mines, as and when they mine, they're doing what we call concurrent rehabilitation, which will then help to alleviate or reduce the amount of financial provision and also the amount of liability on the ground should they close prematurely, or even if they close after the right expires or lapsed. And then old mines that were there before the laws, old mines that were there will fall under the category of derelict and ownerless mines. And we've indicated before in this forum that we have a list of about 6,000 derelict and ownerless mines that we are currently rehabilitating through our SOEs being Council for Geoscience and Mintech. The process is ongoing of rehabilitation. And we've also mentioned that the money that is coming from National Treasury is not enough when we look at the database that we have and the liability that is on the ground. And that is something that we're looking at on the alternative to also talk to Treasury, because this is a legacy of the past that happened more than 100 years ago, where there were no laws on financial provision or rehabilitation or anything relating to environmental management. And what is the plan to ensure that rehabilitation and closure of GNO? I think I've touched on it below that there is a process that we are running with Treasury on a 3-year basis in terms of the MTSF on the allocation for rehabilitation of derelict and ownerless mines and closure. And the closure of these mines will not be the same closure as of operating mines, because the one of operating mines is currently done by the holders to the satisfaction of the department. And if they fail to rehabilitate, that's when we take the financial provision that is in place to go and rehabilitate on their behalf. But this one is rehabilitation of ownerless and derelict mines is done through the National Treasury. And again, there was a question on the illegal mining activity that is happening in Mpumalanga that was reported to the department, and what is the role of the department to ensure that there's rehabilitation as a result of illegal mining. And there was mention of the polluter pays. What we currently working on is the process we first try to find the original owner, to find if this activity does not fall under the list of the DNO. If it falls under the list of DNO, then it will be rehabilitated as part of the DNO process. But if we happen to find the owner, then we work through the process of charging the owner with dereliction or non-compliance. And the process of our law, as we've mentioned, will kick in terms of what should happen for non-compliance, because we will not give closure if there has not been any rehabilitation. So there will be no closure on that. We'll force the owner of that activity to make sure that they rehabilitate the mine and then they apply for closure, or else then we start on our process of penalties. And in terms of how often has the DMRE been blocked by the BRP, in terms of the companies, the business rescue process is done in terms of the Companies Act, which is an act that is regulated elsewhere and not within the department. But what the department can do, as indicated on the presentation, is that if there's any claim that we have, and I've mentioned as well that the financial provision does not form part of the asset during business rescue. So the financial provision would be reserved on the side and not form part of the asset of claim. But as the department, when any mine goes under business rescue or liquidation, we've got an interest, because we're not only looking at securing the financial provision, we're also looking at securing the mine to make sure that it doesn't get to have illegal mining, and to make sure that the community does not complain about any criminal activity happening in and around that area. And I must indicate that it is a process to go to court, but oftentimes what we do, we apply what we call administrative justice. We have open discussions with the BRPs to indicate to them the challenges that we have as the department to make sure that the mine does not become a haven for criminal activities or illegal mining. And we have not been to court as yet, but most of the processes of business rescue, they end up in the business being rescued. So it will depend on the kind of business rescue that we are going through. And I believe that if it comes to a situation where we have to go to court as the department to protect the rights of the departments and our communities, we will go to court. And Honorable Malinga, how is it possible that the DMRE can get a consent from the BRP? And how can a court of law force the BRP to pay? Well, in terms of this process, if we follow it to the latter, let's say we go to court, and then we win the case, and then the BRP will have to abide to a court order and make sure that they release whatever that the DMRE is asking for. And the consent of the business practitioner is as a result of the process in terms of the Companies Act. So it's not a process that is run in terms of the MPRDA. Once the right is issued and then the holder goes on business rescue or liquidation, then the process in terms of the Companies Act then kicks in. And then as the department, then we then follow the process in terms of the Companies Act. And then, like I indicated earlier, if we have to go to court, we will then follow that process. Then another question from Honorable Malinga about illegal mining on the mines that are on care maintenance. Do they continue paying for financial provision? Yes, they continue paying for financial provision because they've not applied for closure and they've not been granted closure. So anyone who has a right or a permit and has not been granted closure by the department, they must make sure that they continue to comply with all the laws under financial provision or any other relevant law relating to mining. So basically I'm saying yes, they continue paying the financial provision until they rehabilitate to a satisfaction and a closure certificate is applied for and a closure is issued by the department. And what will happen in practice, that if there's an illegal mining that is happening on the mine that is under care maintenance, we know the holder, and the department will then go after the holder to make sure that the holder discharges their obligations in terms of a right that was issued them. And if they don't charge those obligations, and we go through the process of non-compliance in terms, and then we implement the penalties and offenses as indicated earlier. I'll pause here, DG, and back to you. Please advise me if maybe I've missed any other question, then I can come back to it. Thanks, DG, and thank you, Honorable Chair and Honorable Minister and Honorable members.
No, thank you, Advocate Moloto. Indeed, just to add on your responses as well, Honorable Chairperson and members, our approach has been, especially on the derelict and ownerless mines, and you would have noted the quantum that Advocate Moloto has spoken about, more than 6,000, in fact, 6,100 of those derelict and ownerless mines. The approach has been, we've risk-rated them. What I mean by them is that to look at those that are high risk to communities, including children, and working together with our SOEs, including CGS and Mintech, we've striving to make sure that we rehabilitate and close the holes. But what is important as well is for us, we've been promoting legitimate mining of those, some of those derelict and ownerless mines. What I mean by that, we promote people and we guide them to say, if you want to correctly or legally own a mine, this is a process that you must embark upon. And we've actually been promoting that such areas, including what we call the outcrops. An outcrop is where the mineral of value hits the ground, are mined legally as well. So we've actually taken that approach, including some of the dumps that they actually are mined. And this has been happening not only in Gauteng and partly also in Mpumalanga and some of the provinces. But what we've also done, Honorable Chairperson, is that especially with to try to deal with impact on illegal mining, what we've done is that we've encouraged the companies who've been mining or removing the dams and including the outcrops that, and working together with the municipalities to do construction over those grounds, because our past experiences have indicated that if you just remove the outcrops or the dams, the illegal miners come back and try and dig, you know. So there are areas, including Neguruleni in the West Rand, where construction of can be sports facilities, it can be buildings, can be industrial areas, especially along the major highways have been done. And some of the areas we've taken the PPC. But also what is critical, Honorable Chairperson, is that we cannot do it alone as a department. We continue to work together with the law enforcement agencies. You will recall that when you visited earlier the Gauteng province as a PPC, there were presentations that were received from the SAPS and also the Minister of Home Affairs, Dr. Mutsoaledi, as well, because of you know the illegal mining challenge is very complex. It's not only rehab or legitimate mining will stop that. We'll have to deal with the criminal element, as Minister has previously indicated. So we are collaborating with the police, and you have noticed in the media over some time, there's been significant arrests that have been made by the ACPS, including for those that had ammunition and the police confiscation of that home. I mean, the Minister of Home Affairs touched on what measures are being put in place by the department to deal with undocumented persons as well. But last for myself is that I think through the minister as well, we've been engaging with stakeholders, communities through the respective mining conferences. We had one in Limpopo recently, where we collaborated with the provincial and local government, and we've involved the mining sector. In other words, the business itself, they were there. Our SOEs were also there. Community reps were also there, just to share the information. Because one of the things that we picked up is that beyond the fact that those provinces, there's high potential for investment in mining, I think the main issue is sharing of information. And I think there were interesting discussions that took place, including in Limpopo, as I've said, the Rustenburg area and the Northern Cape, just to share that information and also to share what the companies are doing to benefit the respective communities. So I think it's a continuous process that we are going to embark upon. Yes, there are still challenges, but we believe that they are insurmountable if we constantly work together with the other stakeholders. I'll also end up there, Minister. Thank you.
And I think that is it, but only 2 points I want to make. The department doesn't have a plan for illegal mining. We can't plan for a criminal activity. It's not within the scope of the department. But what we have tabled to this comment is that every year we receive about 140 million rand. That covers about 40 holdings per annum. And we're trying to stick to that as much as we can. That's why, as we're closing the holes in the East Rand, when there was a disaster in Krugerstown, we directed our energy to that. So 140 million rand per annum, too little, but at least it can cover 40 holdings per year. We can't plan for illegal mining. The last point I want to just clarify is that care and maintenance is not a derelict mine, it's not an ownerless mine, it's part of an operational mine. If a mine is put on care and maintenance by a particular company, that mine belongs to that company, and therefore contribution continues. Thank you.
Thank you, DMRE. I take so that we are still seized with the issue of illegal mining. But thank you. It seems to me there is assurance that systems are in place and solid with regards to the rehabilitation funds and financial provisions, and are able to kick in. The only issue is intervening situations that probably might be beyond the legislative powers and capacity with regards to the issue of the BRPs, which may have more cost implications due to the challenges that goes with it. Without any further issue, can I then open up to honorable members to deal with the issue of the licensing regime or the cadastral system? Going one, I see the hand of Honorable Lorema. 1, 2. I see the hand of Honorable Madogwe. 1, 2, 3. There's only 2 hands. Honorable Lorema and then Honorable Madogwe.
Thanks, Chair. I'd like to ask questions around 2 areas. And these concern, I think, mostly slides 9 and 10. What does data cleansing mean? Does it mean you're tackling the double granting of rights? Is that part of it? Is the double granting of rights seen as a significant problem? And are any of the provinces particularly bad in this regard, in this situation of double granting of rights? The second area concerns really the need for a breakdown of the license applications that have been dealt with, this 43.5%. Do you have a breakdown, or can you give approximate numbers of how many of those licenses have been granted, how many of them have been refused? And in the cases where they've been granted, are those companies still around to take those up? You can imagine the situation where a company has been made to wait for several years. It's possible that the source of their funding has dried up or moved elsewhere. So I guess the final question there is, how many of those licenses that you've granted are actually mining? Thank you.
Thank you, Chair. I think my question is around the assertion, or rather the assertion that there is currently or there are challenges around procurement of a service provider. And I think that these were, perhaps, I think that it is commended that the SITA was able to actually see on time before things went out of hand that there would be problems. But what I'm interested in as well is that the department is surely aware that the issue of issuing licenses, it is something, or it is a task that it will always be seized with. And the issue of the cadastral system, it's something that has been ongoing for years. And at this point in time, I think every time there are questions around this, we'll be told, no, we're working on it, there will be improvement and all these things. However, because this is a task that it is known, and one could actually even argue that this is a crucial and perhaps a service delivery task of the department. So why hasn't the department perhaps considered having a, not necessarily department, but rather that this matter or the issue of issuing licenses, including the systems, including the technologies, must be done internally? That is the first question that I have. And then the second question, I think it is in relation to the consequences or the consequence management in the department in relation to staff members, then perhaps I would say staff members for now, or employees, it could even be officials, we are not sure, who have actually been implicated in the sense that there were investigations. And some I would like to assume that they were found to not have been doing their work diligently. I think the DDG even alluded to the fact that people do not necessarily need to wait up until there's monitoring from upper level management for them to do their job right. But the reality is that each and every person knows when they're doing wrong things, and they do not necessarily have to have had someone saying, look, there'll be consequences, or someone overlooking over them. So I'm interested in what has been, in terms of the investigations that have been done, what have been the consequences outside just culture change, and putting monitoring tools, in putting up monitoring tools, but what have been the general outcomes? How many people have been implicated? Have any been suspended? If in any way the decisions that have been made by these employees have actually cost the department, has anything been undertaken in terms of recouping the financial losses for the department? And I think why it is very important as well, that this is important, is because some of the reasons why people actually end up engaging in illegal mining activities, it's because they would have been waiting for years on end, waiting for their licenses to be approved. And that again goes to that we're then having repercussions for that, which we all know what they are, including environmental impacts, which at this point in time, even in this meeting, the department has sort of alluded to the fact that there is no plan to actually deal with the consequences of illegal mining, which therefore means that people will just go and dig anywhere they want to, and the communities that are there will just have to see to finish in terms of the implications of that. So it's not just an issue of failure or a delay in issuing mining licenses, but it is actually a feeder into much bigger problems for not only communities, but the country as a whole. So that is my second question as well, in terms of what have been the consequences. Have people been suspended? Have any monies been recouped? And also whether there are people whose conduct has been found to have some criminal or corrupt elements, and whether those people were in any way referred to the relevant state organs. Thank you, Chair.
Okay, thank you, honorable members. Honorable Minister.
Let me give Social Hilda to respond. I will come in later.
Thank you, Chairperson, and thank you, Honorable Minister. I will attend to the questions that were asked by Honorable Madogwe, and I will request DDG Makubela to respond to questions from Honorable Lorimer. Honorable Madongo, you asked the question why we do not consider procuring this system internally. I must indicate that we can procure the system internally, but unfortunately, we are legislated. Actually, there is a legislation in the CETA Act. CETA is mandated to procure certain IT services for government departments. Therefore, we are bound by that act, and therefore, on some services, we are unable as a department to procure on our own. However, I must indicate that while CETA procures for us, there are officials that we second to work on the project with CETA because they better understand the environment. Secondly, as well, in terms of procurement processes from a PFMA and Treasury regulations, there are certain ICT services procurement that are dedicated for CETA to procure, And what they look at is the procurement price threshold. If procurement exceeds a particular price threshold, those cannot be handled by the department and are therefore handled by SETA. If you recall, when I did the presentation, I had indicated that at the point where we finalize our specification, we are engaging with SETA just to concretize if we can advertise ourselves or to look into the legislation as to whether we can hand over to them. And as soon as that is clarified, we will be able to get an indication whether we are procuring internally or through SETA. I think I have covered the questions. One of your questions was on consequence management, and I will hand over that one to DDG Machubele. It was consequence management and the culture issues. Thank you.
Thank you very much, Honorable Chair, Honorable members, Honorable Minister. Firstly, the issue of data cleansing asked by Honorable Lorima. So what we've done is that we've sent the teams basically from from head office to each of the regions, basically to check whether the data is loaded on SAMRAD. And I can indicate that what we are picking up is that there is a culture of not loading data. So they don't upload colleagues, I guess, also partly because they are pushing volumes, but that's where the mistakes can happen. So the team from headquarters has been basically assisting the regions to load, to upload data, particularly on coordinates, and checking that the polygons actually are the correct ones, because that then leads to the issue of double granting. If the polygons are wrong, if information has not been loaded, because then the person who's doing the assessment has no way of actually picking up that there's already a license that has been granted on those particular coordinates. So that work is proceeding. We're 70% done, and we should be finished with all of this before the end of this calendar year. We had anticipated that we would be having a new system. So we didn't want a situation where we load wrong information onto the new system, because then it will defeat the purpose. But I think that we remain ready then when this exercise is finished to give assurance to IT that the information that sits now in SAMRAD is credible. The issue of the breakdown, I think we have not done a complete breakdown, but we can provide the figures. But what I can indicate, for example, is that in the last 2 quarters, we have had 311 refusals versus 168 granted prospecting rights. So the vast majority of applications that come to us, effectively, they end up being refused. But we can provide that for the ones that we've done, that we're reporting on. We will provide that in writing if we're given the opportunity before the end of this week, because it's not It's just to compute the figures, we can provide that. Then on the double granting, the double granting remains an issue. Basically, the provinces that are affected, it's mainly the big ones where there's a lot of activity. Your Northwest, Northern Cape, Mpumalanga, and Limpopo. So, in fact, we do have a program now to assess actually, again with the internal audit, whether there's been progress in terms of minimizing that. Then on the issue of the consequences, I think the issue here is that the big thing is the culture issue. And we are turning around the culture. That has been the main focus. Because wherever you look, you then find that there were entrenched practices that effectively, allowed certain things to happen. So what we have done, and I think it helps to have the right tone at the top, because then that helps, us to then infuse that new culture right through the organization downwards. And these conversations are continuing, and we are finding that we are actually making more progress through ensuring that people, they realize that, one, they have to do things even when they're not watched, but also know that someone is watching all the time. So to give that encouragement to change the culture. So that basically has been the focus. In as far as involvement of law enforcement agencies, at this stage, we don't have cases that are active that we know of that have been recommended by us. That is not to say there aren't cases that other aggrieved parties, will be, raising with the law enforcement agencies. But I really would want to indicate that this thing about the tone in an organization, we are finding that we are actually achieving more successes rather than, the stick approach. Thank you.
Honorable Chairperson, those are the answers, except that I must just comment on one. Honorable Matokwe, always see illegal mining as a fault of the department. I think that is a very unfortunate, because many of those illegal miners walk across the border with heavy weapons, have not applied for any licenses. They're here to steal gold, to steal coal, to steal precious metals. They have not applied for any license. So it is not logically correct to say illegal miners are a consequence of waiting for years for licenses. Majority of illegal miners, that's why when you hear 21 people die in a hole in Krugerstown, you will hardly find a South African there. So I don't understand this logic of illegal mining and licensing being linked. I think it's very unfortunate. Otherwise, these are the answers.
Okay.
Sorry, Mr. Chair. Can I just ask for one more point?
I was going to ask, is it a legacy hand or a new follow-up hand?
No, it's a follow-up, Mr. Chair. Sorry, I don't know if you've seen it or not.
Okay.
So can I just ask one more thing about that table on page 10? Does that include mining permits in those stats? Because that doesn't seem to be clear.
This is a direct question. That's the only question, Honorable Minister. You can pass the ball. I know we are was no shy to pass.
If you go through that, table, you'll see that there is actual categorization of what has been dealt with. There is an issue of prospecting rights, which talks to 1501, which is line number 1, 2, 3, 4, 5, 6. But Hilda, can you please clarify that? But that category is actually quite bold. Mama Hilda.
Thank you, Minister. DDG Makwela, may I request that you deal with the statistics? Thank you.
Okay. Thank you very much. Yeah, so the table does not deal with the mining permits. And that was from our side deliberate, because the vast majority of mining permits are basically, they give a distorted picture. They are in the Mpumalanga region. In fact, about 800 of them are in the Mpumalanga region. And then they tend to distort the actual progress there that is being made. And the 4,000 that we were comparing to, 4,647, basically talks to the categories that are being reported on the mining permits, the prospecting rights as well as the mining rights. We've limited ourselves to that. Thank you very much.
Okay. Thank you very much. I'm trying to be as fair as possible. I think we are done for the day. Any last words, Honorable Minister?
Thank you very much, Honorable Chairperson. One thing that encourages us to come to the portfolio committee is that our debt and risk, when we have a sense that it is not, we'll always articulate that. When we come out of a portfolio committee, we go back and revisit the portfolio committee meeting, see what lessons can we draw from the questions. And that's why, for example, that schedule on backlog, on status on backlog is quite important because it breaks it down. I think we should go through it and read it. I had a very different view of it than what DDG Makwela was saying, because the breakdown is on mining rights, it's on renewal of mining rights. It is on section 11, section 102. It is in SLP. It is in prospecting rights, which are actually prospecting like permits. Section 1811, 102, and it goes on like that. My own view is that we'll have to go through that, and if we need to add more information, we're ready to do so. Thank you very much, Honorable Chairperson.
Thank you very much, Honorable Minister and the team for your availability and the presentation that have been made. Obviously, from time to time, we will have such interactions, these committees, I always say they are about information sharing, they are about accountability, but at the same time, they are about empowering each other. And I think that is the nature of the spirit, that our even engagement must always be constructive engagement that seeks to find solutions to the challenges that we are faced with. And on that note, I think we can release the department, but if they still want to keep us company, we don't have a problem. We enjoy the company. Is there any other matter, Ari?
It's the 2 sets of minutes of last week, Chair. 1 and 4 November.
Okay.
Okay, thank you, Chairperson. Actually, we can't keep you company. It's very good to keep you company.
Okay. Have a great day, all of you. You need it. Okay. Number 1. Okay. Is there any mover of the minutes? Is there any mover of the minutes? Going 1, going 2.
They are mover, Chair.
Oh. Is there any seconder? Going 1.
I second, Chair.
Thank you very much. Is there any matters arising?
Last bullet on the before adjournment, Chair. That's what we agreed on. So it's captured correct. So I'm not sure if we still want to elevate it.
Yes, we, in the discussions with MENCO, wanted to recommend to the committee that the matter be referred, because it was an instruction to the committee by the House Chairperson that we go back to the House Chairperson and say, as the committee, we are of the view that because the matter, it has got from its origins, wherever it had happened, it is a matter that relates to the criminal justice system, and therefore, as the portfolio committee, we recommend that we work together. There must be a joint committee work led mainly by the portfolio committee on justice and correctional services in looking beyond, so that invitations can be made, for instance, to the NPA, the Hawks, and any of those that are relevant institutions that deal with matters, even the commercial crime related matters. So if the committee agrees, that letter will be sent to the House Chairperson on the work that the committee has done. That's the recommendation that we were putting into the committee.
Agreed, Chair.
Is there any second of that? Going one.
My second, Chair.
Okay. Thank you very much. That's what we will do. Is there any matter on matters arising? Ari? Nothing. The second set of minutes?
For November, Chair, last week Friday.
Yes. Standard issues, attendance done. Yes, the issue was on the upstream petroleum resource development bill. That was the only item. Is there any move of the minutes? I don't see. Going one.
I move for the adoption, Chair.
Thank you very much, Honorable Volmarans. Any seconder?
I second, Chair.
Thank you very much, Honorable President. Is there any matters arising? The only matter that is matters arising, we said before we will only deal with that. Members must keep us in touch or in check. We said members must be working on the actual areas so that when we do on the final leg of the committee work for 2022, we will then be talking with the specific areas in terms of the upstream petroleum resources development bill. That issue will remain an outstanding matter until we adopt the public hearings program. Is there any matter on matters arising? In the absence of any other matter, Ari, is there any issue of a correspondence?
No, Chair. Not now, Chair. We'll deal with it next week, Chair.
There is I must say, because it might come to honorable members. I don't know. Maybe they got it. There is the issue areas of Mossel Bay and Petro SA, although it has not been sent directly to us. We are trying to do a follow-up, see what is actually happening in the area. Honorable members will recall we had engaged with the municipality in the main, which we expect that whatever that is part of the correspondence, it will include the municipality because that's a statutory structure of government, including the district with regards to those challenges. But the manner in which it is happening, it seems again, we might be going back to square one, but we will find a way of how do we deal with the matter because it has not been directed to us as a committee per se. But as I said, that members will recall when we had that discussion, it included because of corporate governance in nature. We may have, we will follow up, and then if it requires that it must again receive the attention of this committee, we will have to act in that manner. Honorable members, in the absence of any other matter, can I release you? The meeting is adjourned until when, Ari? Friday?
No, Chair, we don't have any meeting scheduled for Friday. Next week, what is it, the 15th, Chair?
I must send an invoice to Honorable Mylem because I've saved the day for him on a Friday. On that note, honorable members, The meeting stand adjourned. Thank you very much.
Recording